Hello friends, in today's session I will be discussing government's liability under contract. In the era of welfare state, government economic activities are expanding. Daily government is entering into contracts for varied purposes like construction, management, maintenance and repair, manpower, supply, IT related projects, etc. In this session, we will examine the constitution and legal requirements for a government contract. In England, before 1947, the Crown could not be sued in court on any contract. But after the enactment of Crown Proceeding Act in 1946, the Crown now has been placed in the position of an ordinary litigant. However, in India, history has traced different path. The maxim, "the king can do no wrong," has never been accepted in India. The union and the states are legal persons and they can be held liable for breach of contract as well as in tort. They can file suits and suits can be filed against them as well. As regard contracts are concerned, in our country, the Indian Contract Act 1872 lays down the legal requirement for a valid contract. In section 2H of the Act, an agreement enforceable by law is a contract. Section 10 provides that all agreements are contract if they are made by the free consent of the parties who are competent to contract for a lawful consideration with a lawful object and are not hereby expressly declared to be a void. The Act does not prescribe any form for entering into contract. A contract may be oral or in writing. It may be expressed or implied from the facts of the case. A contract to which the central government or state government is a party is called a government contract. Like other contracts, a government contract is also governed by Indian Contract Act, yet it is distinct. In addition to the requirements of the Act, such as offer, acceptance, consideration, a government contract has to comply with provisions of Article 299 of the Constitution. Let us first see from where the executive gets power to enter into a contract. It is the Article 298 of the Constitution of India, wherein the executive has been given the power to enter into contract. Under Article 298 of the Constitution, the executive power of the Union of India and the state extend to carry on any trade or business, acquire, hold and dispose of property and make contract for any purpose. Further, for entering into contract, the formal requirements, the mode and manner are provided by Article 299. Now, let us see what Article 299 says. According to Article 299, a contract is binding on the Government of India if three conditions are fulfilled. Firstly, the contract must be expressed to be made by the President or the Governor of the state as the case may be. Secondly, the contract must be executed on behalf of the President or Governor. Thirdly, the execution must be by such person and in such manner as the President or the Governor may be direct or authorize. As regard the conferment of the authority is concerned, 299(1) does not prescribe any particular mode. The authority to execute the contract on behalf of the government may be granted by rules, formal notifications or special orders. Such authority may also be given in respect of a particular contract or contracts by the President or the Governor to the officer other than the one notified under the rules. However, the lack of proper authority would render the contract invalid. The last requirement is that the contract must be expressed in the name of President or the Governor as the case may be. Thus, even though such a contract is made by an officer authorized by the government in this behalf, it is still not enforceable against the government if it is not expressed to be made on behalf of the President or the Governor as the case may be. It must always be remembered that for government contracts, the provisions of Article 299(1) are mandatory in character. The provisions are not for the sake of mere form, but for safeguarding the government against unauthorized contracts. The formalities are embodied basically on the ground of public policy for protection of general public, which is represented by the government. Any contravention of Article 299 nullifies the contract and makes it void. Neither the government can be sued nor can the government enforce such a contract against the other contracting party. The Constitution, however, excludes the personal liability of President or Governor. Article 299(2) provides that neither the President nor the Governor shall be personally liable in respect of any contract executed for the purpose of the Constitution or for purpose of any enactment relating to Government of India. It also grants immunity in favor of person making or executing such contract on behalf of the President or Governor from personal liability. As the provisions clearly provide that the contract has to be in writing, there can be no implied contract between the government and another person. The reason being that if such an implied contracts between the government and other person were allowed, they would in effect make Article 299(1) useless. A contract to be valid under 299(1) has to be in writing. However, the expression executed does not by itself contemplate execution of a formal legal document. A valid contract could emerge through correspondence or through offer and acceptance if all the conditions of Article 299(1) are fulfilled. A valid contract may result from the correspondence as well, like where there is a tender for the purchase of goods in pursuance of a tender notice, notification or statement inviting tenders issued by on behalf of the President or the Governor, and the acceptance in writing which is expressed to be made in the name of the President or the Governor and is executed by a person authorized in that behalf will fulfill the requirements of Article 299(1). Now, let us see what will happen if the contract does not comply with provisions of Article 299(1). No doubt, such a contract is not enforceable in the court of law at the instance of any of the contracting parties. However, with a view to protect innocent persons, courts have applied the provisions of Section 70 of Indian Contract Act and held that the government liable to compensate the other contracting party on basis of quasi-contractual liability. However, before Section 70 of the Contract Act is invoked, three conditions must be fulfilled. Firstly, a person must have lawfully done something for another person or deliver something to him. Secondly, he must not have intended to do such an act gratuitously. And thirdly, the other person must have accepted the act or enjoyed the benefit out of it. No doubt, the requirements of Article 299 are mandatory. However, the courts have also realized that insistence on too rigid observance of all the conditions stipulated in Article 299 may not be always practicable. The judicial attitude to Article 299 has sought to balance two motivations. On one hand, to protect government from unauthorized contracts, and on the other hand, to safeguard the interest of unsuspecting and unwary parties who enter into contract with government officials without fulfilling all the formalities laid down in the Constitution. So friends, with this I come to the end of session on government liability under contract and leave you with a few questions which you will find easy now. Thank you for watching this video.